Swayam Prabha. Digital India. Educated India.
Namaskar, I am Dr. Susmitha P. Mallaya, Professor, Faculty of Law, University of Delhi. So in the last lecture, I have introduced you a white collar crime, or in larger terms, the socio-economic offense in the means of insider trading in financial markets. We have seen what a financial market signify, which consists of the long-term and the short-term money market, capital market and the money market. And we have also understood, or we have discussed, who is an insider and the role played by the judiciary and the importance of having the mens rea element and the procedure that need to be followed in order to prove the offense of insider trading. Now, we have seen as a regulator, SEBI plays a very important role. SEBI means the Security Exchange Board of India. Now, in today's lecture, I am going to introduce you the role that is played by SEBI in detail for regulating the insider trading in India. So, let's see. First, let us see the historical perspective of securities regulation in India. How the securities got regulated, or why there was a need that was felt. So, we can trace back the earliest record of the dealings of securities in India traces back to East India Company. So, the Britishers came to India and incorporated the East India Company for trading. So the first Indian legislature to regulate security market in India was the Bombay Securities Contract Act 1925. It was enacted to regulate purchase and sale of securities. So it is the Britishers who came to India, from where we can trace the origin of the security regulations. And the first aspect was the Bombay Securities Contract Act 1925. And it was enacted to regulate purchase and sale of securities. However, the legislature had several shortcomings, which resulted into investors making huge losses during the period of 1928 to 1938. So, what was seen during the period of 1928 to 1938 was that huge loss was faced by the investors in the security markets. So, if you remember, Essential Commodities Act also had its origin from the Defence of India Act. So, similarly, in Defence of India Act of 1939, because that was the legislation that has been introduced again by the Britishers, and remember it was during the World War and all. So, this Defence of India Act included the provision. So, it included a provision relating to the capital issue, which stipulated that the prior government approval was mandatory for the capital issue. So, they made a very stringent legislation or regulation to regulate the capital market. They said that as per this regulation, nobody can trade or nobody can enter into the capital market unless and until the government approves you. So the government approval for trading, for purchasing was mandatory as per the Defence Act. So they made a provision for the capital issue under the Defence of India Act. and the approval from the part of the government was made mandatory. And when India got independence in 1947, the same rule was incorporated in the Capital Issue Control Act of 1947. So when we got the freedom in 1947, superseding the Defense Act of 1939, we made a special act legislation in the name of Capital Issue Control Act, but this act was repealed in 1992. Now, why? The stock market witnessed different phases during 1946 to 47. So 1946 and 47 was the crucial period where the stock market has witnessed. We have seen the Britishers were ruling us, the laws has been made according to their convenience, and now suddenly we got the freedom, and now we are here to look what we have to do, how to regulate it. So the stock market being the internal part of the country's financial system. As I told you, the strong financial market a country have, the country will become more strong and more independent. If the economic progress is less and the economy is weak, then that country will not be a strong or the powerful country. So the strength of the country is not only depending on the armed forces, it is depending on the capital investment, the capital structure, and the capital market, and the market which is the fuel or which is the soul of the economy of any country. So here during that 46-47, the stock market witnessed different phases, and there was the stock market being the internal part of the country's financial market. There was a need to tighten the government control on the stock market. So the need for tightening the government control on the stock market was felt. So in order to see the government, in order to see how much control is required, the government constituted the Thomas Committee under the chairmanship of P.J. Thomas, who was the advisor to the Finance Ministry. So under his chairmanship, the committee was constituted, and the committee advised that an independent and quasi-judicial authority with the fullest powers and supervision could only discharge such a function, and thus recommended setting up the National Investment Commission. Right? So they recommend, this is a recommendation from the part of the P.J. Thomas Committee, that that is the power and supervision could discharge function, setting up a National Investment Commission. There is a need for a National Investment Commission. Now, what about the insider trading? The instances of insider trading in India was first reported in 1940s. It was reported in 1940s, and directors, agents, auditors, and other officers were found to be using the insider information for profitability, speculating in securities of their own company. So we can see that in 40s, the instance of insider trading was first reported in India. Now, apart from the Thomas Committee, there were other committees also. So let us look into the recommendation of various committees for regulating insider trading in India. So as we have discussed, the first committee was the Thomas Committee in 1948. Soon after we got the freedom, the Thomas Committee was appointed. So the committee has analyzed these instances of insider trading and observed that insider trading occurred how? First, the possession of the information by these people. So why the insider trading is happening? Because of the possession of information. By whom? By these people. These people means those people who are associated with the company in one way or other. Now, before everybody else, so they are coming to know about the possession or information because they are closely associated with it. Before coming to know or before becoming it to the public, they are getting the information. Then regarding the changes in the economic condition of the companies, and particularly regarding the size of dividends to be declared, the issue of bonus shares. So here what is the scheme that government is going to introduce and how it is going to benefit our company, whether we need to shift from the coal to fuel, whether what is the other means where we have to invest. We have seen from the traditional method we are moving towards the technology. So now investing in the technology will give you the more inputs or more profit, right? Renewable energy. We are now moving towards the solar and the renewable energy from the environmental name for the sake of environmental protection. Now those companies who are dealing with the other non-fuel, or we can say that those companies who are traditionally working in the factories, they will shift to the renewable energy. So now shifting from one to other. So this is the sensitive information which a person will acquire because of his close associatedness with the company. So that is what the Thomas Committee found, that this is the instances because of this information that they are getting, and he pointed out the lack of this special legislation. So what he was saying is that there was no legislation, there was no special legislation to deal with the unfair use of insider information. So there was nothing with respect to the unfair use of insider information. Now, followed by the Thomas Committee is in 1979, the Sachar Committee was constituted, and it recommended the amendments to the Companies Act of 1956. So the Companies Act of 1956. So this is the legislation. So Companies Act of 1956 was the legislation that deals with the administration of the company. We were not having any special law. How the companies were administered, it is through the 1956 Companies Act. And the Companies Act contained a lot of provisions regarding its administration, regarding the shares, regarding the debentures, regarding, who can. So there he submitted, or he suggested for the amendments and restrict and prohibit the dealings of the employees. So whether the directors can be the employees. So the restrict, the prohibit dealings with the employees was there, and the penalties suggested for the penalties to prevent the insider trading. So we can see that the separate legislation was not there. However, certain amendments were suggested in the Companies Act itself under the leadership of the Sachar Committee, and accordingly followed by, after 10 years later, in Abid Hussain Committee 1989, it recommended that the insider trading activity may be penalized by the civil as well as the criminal proceedings, and also suggested the SEBI formulate the regulations governing courts to prevent unfair dealings. So what we can see is from 1947 to 1989, there was no specific legislation or regulation to deal with the concern or the issue of the insider trading in India. We can also say that it was not treated as an offense. It was considered as a normal practice. So we have witnessed a lot of scams during time. Harshad Mehta, stock exchange, Harshad Mehta became the torch bearer, we can say. That scam became the eye opener. A person who was a stockbroker became so much of extremely reaching a peculiar heights. The value of the shares extremely went high, and then suddenly there was a drop. So then followed by other 2-3 scams happened, and then there was a realization that was felt in India that the scams are happening, and the scams are happening in the name of the information that is received by the insider. So there is a high time to have a specific or a specialized legislation to deal with this. So the amendments that are provided, or the provisions for the penalties provided under the Companies Act, are insufficient to address the issue of insider trading was felt. And so the Hussain Committee recommended to constitute the SEBI as well as to penalize it not only as a civil offense but as a criminal offense. So both the civil and the criminal. So both, this is a peculiar feature. It's a civil as well as a criminal offense has been introduced and recommended by the Hussain Committee. And the codes, that is the code to govern the unfair dealings, was also recommended by this committee. So these are the recommendations of the various committee for regulating the insider trading. Now, having said that, the regulations on insider trading in India was formulated. First, to begin with, the Security and Exchange Board of India Act of 1922, that is the parent legislation governing or regulating the security markets in India. The capital market is regulated by the SEBI in short form, and followed by that, with respect to after 1992 itself, a special regulation, that is SEBI insider trading regulation, was formulated in 1992. So SEBI's act, based on that, the regulation, main act, parent act, followed by the Insider Trading Regulation Act of 1992. Then it is only the SEBI insider trading. Followed by that, SEBI prohibition of the terminology of prohibition was used. Prohibition of insider trading amendment regulation was happened in 2002. So remember that 1990 onwards, we have opened up our economy for liberalized and the globalized policies. So that became the platform for the government to initiate or to make the amendments in the rules and regulations to control the capital market. So 2002 was another amendment was made to it, and in 2003, for 2003, the SEBI prohibition of insider trading amendment regulations again. Then SEBI prohibition of insider trading amendment rules in 2008. Then SEBI prohibition of insider amendment regulations 2011, and then the SEBI prohibition of insider trading regulations 2015, and latest now they have SEBI prohibition of insider trading amendment regulations of 2025. This is the very much recent, and it came into effective from June 9, 2025. So it has been hardly going to be 1 month. So so all these, remember that these are the amendment. So the first is the regulation of 1992. So the main act is the SEBI Act of 1992, followed by the first provision to regulate the insider trading was incorporated under the SEBI Insider Trading Regulation 1992. Followed by it, this regulation has been amended from time to time to incorporate the changes that is required to regulate the market. So first starting with the 2002, 2003, 2008, 11, 15, and now the latest is the 2025 regulation to regulate the insider trading in India. Now, let us discuss some important aspects of prohibition of insider trading. I'm just discussing some of the important aspects. So one is the insider. Who is an insider? First is, we have discussed what is insider trading means in the last class. Now, who is an insider? Who is an insider? So insider person means a person, connected person. So that is very important. Connected person in a contractual, so it's not a permanent employee, contractual, or a fiduciary capacity, a lawyer, a person who is giving advice. Outsiders who possess, so outsiders, it is not that all persons, outsiders who possess access. UPSI, what is that? UPSI signifies the unpublished price sensitive information. So that is what UPSC. It is not UPSC, UPSI. That means unpublished price sensitive information of what? The financial results. Okay. So the unpublished price. So what is important terminology? Is price. Unpublished price sensitive information of what? Financial results. It may be the dividends, change in the capital structure. All this will have an impact on the capital market because the company is going to change his capital structure. The company is going to declare the dividend. How much is the dividend that the company is going to declare. All these will come under the perspective. So insider means a connected person who can be a contractual, non-contractual, and or a fiduciary capacity outsider, but he need to access what? Unpublished price sensitive information. Now, another aspect is the mergers and acquisitions. So he is coming up with the merger. So if the company is going to merge or the company is going to acquire the shares, all this will have an impact on the economic situation of a company. If a company which is not functioning properly, now a big company is going to come and purchase it, the shares of that company may be less in the market, but now a big giant company is going to acquire it. So it is natural that the shares of those company is going to increase. So this information is there. Then the person whoever is acquiring is going to get the benefit of it. Now the change in the key managerial personnel. So here KMPs means key managerial person. Okay, so if a person is going to change from, then that will also have a very impact on. It can be a good impact also, it can be a bad impact also. So it depends upon the person who is going to change. Shifting of the managerial person will have an impact, because see, this is depending on, we all know about the Ratan Tata, and also it's a very famous, right? So we have the trust. So when there is going to be change, if you have witnessed the market, the stock exchange is like the huge jump and huge loss. Why? Because a person is going to change. So that is one of the aspect. Then the communication and the procurement of the UPSI, that is again unpublished price sensitive data, banned except for due diligence. So if it is for the due diligence, then that is accepted. Now, who is the burden of proof? Burden of proof is on an insider. So insider is expected. The burden is to prove that he has not used. It is on the insider. Now, what are the defenses? The defenses are off-market inter-se transfer. That means the person in possession and the person taking trading decision different. And what is a trading plan? It includes buying, selling, subscribing, and dealing. Another important aspects of prohibition of insider trading deals with the internal codes for fair disclosure and conduct. There is a need for internal codes for fair disclosure and conduct. Then there is a requirement of compliance officer window closure or the prior approval. So these are some of the important aspects that are addressing the prohibition of the insider trading regulation. Now, the question is, why there is a need for prohibition of insider trading? What if the insider trading is there? Why you want to prohibit it? What is wrong in insider trading? What is wrong in insider trading? It is fine. You are getting some information, you are passing on it. How it is going to affect you? Why the public need to worry? Why the government need to worry? Why there is a need for prohibition? I am not committing any crime. I am not committing any theft. And it is my company. It is my company. I am working on it. So how it is going to affect? Why there is a need for prohibition? Now, one is there is a need for insider trading because the market needs to have the faith in the company if the person need to invest. So for that, it need to be fair and transparent. First is fairness. To bring the fairness and the transparency, there is a need for prohibition of insider trading. To bring fairness and transparency. Secondly, to have a level playing field for all the participants in the market. That means it should be equal for all. It's not that being the director, you are in a better position than me. Of course you are, but I am a shareholder. I am investing in it. My hard-earned money is investing. So don't you think that I also should get the share of it? And you are a director. I have also accepted your directorship because I thought that you are a person who is of good faith and who will be transparent in your dealings. So there is a need for a level playing field for all the participants in the market. So there are a lot of participants in the market, the creditor, the debtor, all of them, those who are giving some goods for the company, trading with the company. So everybody should, it's a matter of trust. So there should be a level playing field. Then for a free flow of information and avoid information asymmetry, there should not be any kind of confusion. There should not be any kind of confusion. So in the company law, there were cases, that is a company which the object was to get to German dates, the patent of making from the German dates, but however they did not get the patent. Now the intention for which has been futile, it was not intended. So here there is a free flow of information and avoid information asymmetry. So there should be a constant flow of information without any kind of hindrance. Then the rapid advancement of the technology has made it easier for the insiders to access and disseminate non-public information and create new avenues for the potential abuses. So it has become a platform for the potential abuses. Additionally, the global nature of the financial market presents the jurisdictional challenges, as insider trading can occur across borders, making enforcement more complex. So there is a need for prohibition. Once, if you remember in the last lecture, I have mentioned that one of the challenges that is faced under the insider trading before the courts is to prove, that is the evidentiary value. You need to prove the evidence. So it is very difficult to get the evidence. So instead of that, prohibit it. So that is why jurisdictional challenges are there, and insider trading can occur across the borders. So that means international perspective also we need to look into. So, and it will make the enforcement more complex. So that is why there is a need for the prohibition of insider trading. So it is prevention better than cure. You prohibit it, because once it happens, then taking the evidence and proving it beyond the reasonable doubt, proving that there is intentional, it will take time or delay, or maybe we are not in a position to prove it also. So there is a need for prohibition of it. Now let us look into the definition of the key terms under the SEBI regulation. So what are all the key terms under the SEBI regulation definitions? One is the insider. We have already discussed it, but still let us look into it. Insider has been defined under section 2 subclause G. Is a person who is connected with the company, who could have unpublished price sensitive information or receive the information from somebody in the company. That is one of the definition of section 2G. Then under this definition, an insider would mean a person in possession of or has access to price sensitive information or connected person. And SEBI defines insider to include persons connected on the basis of being in any contractual, fiduciary, employment relationship that allows such people access to unpublished price sensitive information. So it is very important. It should be the price sensitive information. So that is how the insider has been defined under section 2 subclause G of the regulation. Now moving further, section 2 subclause D. So section mentioning about the connected person. Now who is this connected person means? Who is the connected person? Again, section 2D defines the connected person means any person who is or has been associated with company in any manner during the 6 months. So that is what, 6 months prior to the concerned act. So you are passing on the information after 6 months. So that's 6 months. So after 1 year, 2 years and all you are passing on, because it is not at all a sensitive information. So 6 months is the period that has been prescribed for passing of the information, and immediate. So he can be an immediate relative to the connected person, a banker of the company, an official of the stock exchange or a clearing corporation, a holding or associate subsidiary company. It also covers persons holding any position that allows access to unpublished price sensitive information. So that is what a connected person means. Immediate relative, a banker, a solicitor, all these persons come under the purview of the connected persons with the company. Now section 2 subclause L, it defines trading. What is trading means? Trading includes subscribing, buying, selling, dealing, agreeing to buy, sell, subscribe, deal in any securities. That is what the trading means. Now, the most important definition, what do you mean by unpublished price sensitive information? I have been mentioning you repeatedly regarding the price sensitive information. It is also defined. That is the best part. It's like what is that information has been defined under section 2 subclause N. That's very important. So the so-called unpublished price sensitive information has also been described and defined under the regulation. What is it? It means information relating to a company or its securities, directly or indirectly, that is not generally available, which upon becoming generally available is likely to materially affect the price of the securities and shall ordinarily but not restricted to information relating to the following. What are all they? Financial results, dividend, change in capital structure, merger, demerger, acquisition, delisting, disposals and expansion of businesses, and such other transaction, changes in the key managerial personnel, and the material events in accordance with the listing agreement. So these are all the informations which are unpublished and sensitive information. Now, what is a trading plan? Regulation 5 describes a trading plan. So trading also has a plan. Just like we have the lecture plan, the trading is also done according to the plan. What is that? An insider shall be entitled to formulate a trading plan and present it to the compliance officer. So that means now we will look into who is this compliance officer means, for approval and the public disclosure pursuant to which trades may be carried out on his behalf in accordance with such plan. And this provision intends to give an option to person who may be perpetually in possession of unpublished price sensitive information and enabling them to trade in securities in the compliant manner. So this trading plan is very important, that it will formulate and it will present to the compliance officer on, that means we will be going with this is the plan and we will be possessing it, and we will be trading in the securities in this manner. So that will be presented before the compliance officer. Now, who is this compliance officer and what are his duties? So we have seen the importance of a compliance officer. So these are all parts of the SEBI regulation to deal with the insider trading. So SEBI prohibition of insider trading regulation of 2015, it defines compliance officer under regulation 2 subclause C, which means any senior officer designated so and reporting to the board of directors or head of the organization in case if board is not there, who is financially literate and capable of appreciating the requirements of the legal and regulatory compliance under these regulations, and who shall be responsible for compliance of the policies, procedures, maintenance of records, monitoring adherence to the rules of preservation of unpublished price sensitive information, monitoring of the trades, and the implementation of the codes specified in this regulation under the overall supervision of the board of directors or the head of the organization, as the case may be. So the compliance officer is also plays a very important role for regulating the insider trading in the company. And we have seen the trading plan is submitted before him. Now, what are the restrictions? So there are certain restrictions on the communication. So no insider shall communicate, provide or allow access to any unpublished price sensitive information relating to a company or securities listed or proposed to be listed to any person, including other insiders, except where such communication is in furtherance of legitimate purposes, performance of duties or discharge of legal obligations. Now, no person shall procure such from or cause the communication by any insider of unpublished price-sensitive information relating to a company or securities listed or proposed to be listed except in furtherance of legitimate purposes, performance of duties or discharge of legal obligations. So, the communication is restricted for an insider. He cannot just say and you say the information to each and everyone. Now, there are certain exceptions to this communication can be said. That what are they? Notwithstanding anything contained in this regulation, an unpublished price-sensitive information may be communicated, provided, or allowed, or to, or procured in connection. What is that? To entail an obligation to make an open offer under the takeover regulation, where the board of directors of the company is of informed opinion that the proposed transaction is the best interest of the company. So, in the best interest of the company, they need to communicate it. They cannot hold as a price-sensitive information. They not attract the obligation to make an open offer under the takeover regulation, but where the board of directors of the company is of informed opinion that the proposed transaction is in the best interest of the company, and the information that constitute unpublished price-sensitive information is disseminated to be made generally available at least 2 trading days prior to the proposed transaction being effected in such a form as the board of directors may determine. So, that is an exception where there is no prohibition that the communication can be communicated. Now, let us see into the regulations under the SEBI prohibition of insider trading regulation 2015. Regulation 3, I am just reading out the important regulations. Regulation 3 deals with the communication or procurement of unpublished price-sensitive information. Regulation 4 deals with the trading in possession of unpublished price-sensitive information, permission and limitation. Regulation 5, trading plans. Regulation 6 deals with the disclosure of trading by insiders. Regulation 7, subclause 1 deals with the initial disclosure. Regulation 7, subclause 2 deals with the continual disclosure. Regulation 7, subclause 3 deals with the disclosure by other connected persons. Regulation 8 deals with the code of fair disclosure and conduct, followed by, let us see the recent or the latest highlights of the SEBI prohibition insider trading amendment regulation of 2025. They have expanded the definition of unpublished sensitive information, and it includes now the events like the contract awards or terminations, credit rating changes, including the ESG related changes, proposed fundraising activities and litigation outcomes. Now, you see, we have changed a lot in our market. We have changed the way the information is provided. Now we are using the chat GPT to know the outcome of our case. This was never ever thought about it. Your assignment, everything is now done by the AI, chat GPT. You are just getting it. You are asking the strategies. You are asking for the strategies. If I want to win the case, what are all the strategy I need to follow for the opposite party? What are the provisions that I can use? So now even for a lawyer and even for a judge, they need not use their brain. That is how things are moving upon. Everything is done by the chat GPT. So now what is happening if we are not including like the award? So what will be the award? So because the companies are going for the arbitration. Arbitration provides the decision, that is the award. So what will be the outcome of that award will have a huge repercussions of that company in the market. So these were not thought prior. So now all these they have expanded to bring it. Then we can see that the environmental related regulations, that is also the price sensitive information. Okay, so the in 2025 June onwards, the definition has been expanded to include this perspective as well. Apart from that, now we are having the digital world. So the structured digital databases, that is also how to use the SDDs for maintaining and updating the information, particularly regarding the non-entity unpublished sensitive information, is also made part of the 2025 regulation. Then it also includes the 2-day timeline for non-entity UPSI, that means unpublished price sensitive. That is a firm 2-day timeline is introduced for updating the non-entity unpublished sensitive information into the structural digital database. Then the flexibility with the trading windows. The need to close the trading window in certain cases, especially when they're dealing with the non-entity UPSI, is relaxed now. And there is also the real-time tracking of trading activities. So this is the amendment's aim to improve the digital disclosure and ensure the real-time tracking of trading activities with the focus on the accountability from the compliance officers. So we have seen the important role the compliance officers need to play. Now, moving further, trading commencement period for insiders reduced to 120 calendar days. Insiders are now exempted from maintaining 12-month trading period. Parameters broadened for each trade execution with the clear price limits. SEBI clarifies trade splitting duration to prevent misuse. They have clearly said that how much and what is the time split. Now, deviations from the trading plan. We have seen what is the trading plan. So, if you are deviating the trading plan, it is allowed only in exceptional cases. It is not that you have given the plan and later on you are going and again submitting or changing it. You cannot do that. So, only the exceptional cases they have mentioned. And insiders must execute trades only within the set of the price limits. So these are the amendments that has been brought recently in 2025 with respect to the insider trading under the SEBI. So we can see that SEBI is constantly trying to regulate the market by way of prohibiting the insider trading because it is the need of the time. Now, what are the penalties? So penalties are of two types. One is the monetary penalty. Section 15G of the SEBI Act imposes penalty of at least rupees 10 lakhs, which extends to rupees 25 crore or 3 times of profits made from insider trading, whichever is higher. And it also requires, or it also have the provision for imprisonment. So Section 24 of the SEBI Act 1992 goes to the extent of imprisonment up to 10 years or fine up to 25 crore or both for any offense pertaining to the contravention of the provisions of the Act. Now, it also consists of the informant incentives and rewards. So don't think that the SEBI is regulating with providing or prohibiting the insider trading by giving the penalties. It also provides reward and incentives. Why? As I told you that it is very difficult to prove with the evidence. It is very difficult to cater the evidence. So there may be the persons who can be a whistleblower. He can inform that it is going to happen. So the Section 7 subclause D of the SEBI Regulation 2015 deals with the reward mechanism for informants who provide information leading to the successful collection of recovery of monetary sanction relating to the insider trading violation. So the amount of reward shall be 10% of the monetary sanction collected or recovered and shall not exceed rupees 1 crore or such higher amount as the board may specify from time to time. And this is what is provided under the 2015 regulation. That means providing incentive to the person who is informing that insider trading is taking place and it is amounting or it is successful collection or recovery of the monetary sanction. Then in case if there are more than one informant, then the jointly providing the original information, the reward as specified in the intimation under the sub-regulation shall be divided equally amongst the total number of information. So it will be divided equally. And the reward under this regulation shall be paid from the Investor Protection and Education Fund. So the SEBI consists of, or it deals with having a provision for the Investor Protection and Education Fund. And that is the fund that the SEBI is using. But here, remember that there is no compensatory aspect with respect to those who suffered loss in the market because of the price sensitive information or the insider trading that happens. However, the reward is given for those persons who are giving a clue, and which results in prohibiting, or which results in getting the culprits of this particular crime before the court. Now, the rejection of the claim of reward. Section 7 subclause G deals with the reward shall not be made to the person unless he submits the original information. The information submitted is acquired by the informant through a regulatory industry. If there is already an ongoing case relating to the provided information, if the informant knows that the provided information is false, incomplete and fraudulent and nevertheless submits it, he will not be eligible for the award. So that is what the rejection of it is not that reward will be given to all. Now, protection against the retaliation and victimization. Section 7 subclause 1 provides for the protection against retaliation and the victimization. It says that the code of conduct which protects the employees who signs voluntary information disclosure. So you can voluntarily give a disclosure saying that I have passed on the information from against threats of the discharge, termination, suspension, etc. So by the employer, regardless the information is rejected or accepted by the SEBI. So if the informant is subject to any such retaliation, that means being an employee, you are coming to know that the directors are passing on some sensitive information to other company. So you are informing the SEBI that this is happening, insider trading is going to happen. Now your employer come to know that you are the person who has given the information, so you will get the protection, and he can approach the tribunals or the competent court for the relief. The employer may be charged a penalty if he is deemed guilty and will be required to pay the compensation to the employee. So that is what the protection against the whistleblower. So similarly, protection against retaliation and victimization is also provided under the legislation. Now, what are the tools? What are the tools to comply with the insider trading? Now, there are 3 T's. What are these T's? One is the training. Now, we have seen how difficult, or we can see that the insider trading is such a aspect or such a socio-economic or a white-collar crime that is having a huge impact on the capital market. Now, it is not that all the persons who are associated with it are aware of it. Sometimes a person associated with it, that is the delegated employee, he may not be knowing it. He is on a contractual basis. So he may not be aware that whatever he is discussing outside is a sensitive information. He may not be aware. We have seen that price sensitive information has been defined, right? It has been defined under the regulation what will amount to the price sensitive information. Now, it is not that the employee or the designated or delegated employee will be aware of it. So there is a need for providing the training in the company, or there is a need for the SEBI also to take initiatives by way of the conferences, then the discussions, and then give the brochures, then what do's and do nots, what are all the sensitive information, and how much you can disclose, how much cannot be disclosed. So there is a need for the black and white regulations, and the training should be given to the employees and the persons associated with it. And so that is one of the tool. So then only there will be effective regulation of the insider trading. Having the regulations, having the rules are not sufficient, but assimilating or creating the awareness of such rules are also mandatory. Now, 2025, the SEBI Amendment Act of Insider Trading has brought down the broader definition of the price sensitive information. How many of the employees will be aware of it? Now, what all aspects has been broadened in the terminology of the price sensitive information? So now many of them will be aware of those price sensitive informations that were there in the prior regulation. But the change that have happened, even the award that has been given by the tribunals, or the outcome of the decision by the court, that can also be price sensitive, or we can say that that is also relating to the price, because one of the another aspect was the relating to the price. So how many of are aware of it? So there is a need for providing the training to those persons concerned who are getting connected with the company by one way or other. That is the one of the tool to comply with the insider trading. Second is the technology. We are technologically advanced now. So the technology can be used as a tool to comply with the insider regulation. Then timely disclosure. If you see that 6 months time is provided. So the timely disclosure is also required. You are passing on the information after a year, or say for example 10 months, it's of no use. So timely disclosure. So there are 3 T's that are the tools to comply with the insider regulation. What are they? Training, technology, and the timely disclosure. Now, what is the way forward? So having said this, we have seen insider trading needs to be regulated, no doubt. But having too much of regulation, or the hard regulations, or the harsh regulations, or the tight and the strict regulations will harm the market, because market needs a dynamic approach. Market needs a sophisticated approach where both the investor and the companies, both of them have a good level playing field. So the way forward is the technology, that is, there is a role that can be played by the technology to combat insider trading. How? As the financial markets become increasingly digital, so now high speed, it is becoming digital. So technology is playing a crucial role in both facilitating, so it is a facilitator, and it is combating insider trading. How? The regulators and the market participants must leverage technological advancements to stay ahead of the potential insider trading activities. It is not that we should wait for an offense to happen. We should not wait for things to happen and then to bring the regulation. So that is why the terminology used itself is the prohibition of the insider trading. So prohibit it, nip in the bud, not wait for the things to happen, and the technology can give you the informations how you can use it. So if you are incorporating the technology in this type of services, or the company is using it, then if the information is passed, quickly they will come to alert. So like that, there are a lot of technologies that can be used. Second is the advanced analytics and the artificial intelligence. Now we cannot say that AI is bad, or AI is having the good as well as the bad. So AI can be used for regulating the market. AI can predict the outcome of the market. Now the question may come whether the information, whether the price sensitive information provided or received through the AI can be regulated by the SEBI. This is a question to be thought about. That is the advanced analytics. We are using the logarithm, that is a lot of algorithms are used. So whether the advanced analytics or the artificial intelligence, so our use of the artificial intelligence, whether it can be, suppose if the sensitive information is received by an AI. Now 2025 regulation speaks about the changes that happen. Now can an AI be termed as a connected person? Think about it. Can we say that the AI is a connected person under the definition? No, because it says that it should be a living person. AI is not a living person. So that is coming into it. But a living person is using an AI to acquire the price sensitive information. So can it be done? Can it be done? So that is what we need to think about. Then there is a blockchain and the distributed ledger technology. This is another form of technology. Blockchain and the distributed ledger technology. So those who are very quick and efficient in the technology will gain the price sensitive information more easily than the other. They will disseminate it. So that will also hamper the level playing field. One side technologically sound persons, another side not that much. So we have seen the companies are moving towards the e-platforms. Nowadays, online meetings are happening. Online meetings, then the companies are sending their reports through the online. I mean, through the mails. They are sending the notices through they are reaching the mail. So we have advanced that much. So here there is a need for protection as well. Advancement and quick action is good, but we need to protect the interest of the investors. There will be the investors who are not sound with the technology. You may argue that they need to be, but it will take time. Now, another is the enhanced market surveillance system. There is a need to enhance the market surveillance system. There is a need for advancement. So, which company is using the tool to gather the information? Who is sending the secret agents through the means of AI? So, all this need to be enhanced. Market surveillance system is the need of an hour. Then there is that is what the machine learning for predictive analysis. So the machine will learn. There is no need for you to learn. Now you will be sitting and listening to it, to the lecture. Now the machine will learn on behalf of you. The machine will give exams on behalf of you. So the predictive analysis. So what is the prediction is also an important. So what we can see is that the way the market, the way the stock exchanges are functioning, the way the financial markets are functioning in India has changed a lot. After the COVID, there is a sudden change in the market structure. We have seen there is a huge jump in the technology related market, and the electronic goods and services has become the buzzword. There is very rarely you can find any person without a mobile phone. Mobile phone has been it is not more a luxury, it has become a necessity. So you can see how the things have changed after the COVID, and we cannot go back to those times. It is very difficult to go back. So that is how to access to all. So now we are treating this technology as a reach out point to all. Those who are staying far away in the remote places also will get the access to the education now. So the marketplaces or the markets are also accessible. It is not only in the cities. Of course, cities, there are urban cities. We have the Zomato, the e-commerce platforms are functioning in the urban. But soon you will find the same coming into the villages also, because that is the fast way the companies are reaching in your day-to-day life. So in these aspects, the insider trading will become an important aspect, because those price sensitive, unpublished, remember that if it is published, then no matter what. But if it is the unpublished price sensitive information that a connected person who is an insider is passing to outsider, and if he is getting the benefit or the profit, then it will amount to the violation of the Prohibition Act or the regulation, SEBI's regulation of the insider trading. So what we can say is that in short, insider trading is a white collar crime or a socio-economic offense in general, and SEBI is the regulator, and through the regulation it monitors, it controls, or it prohibits and try to balance the level playing field to see that the harm is not caused much to the society. We cannot say that it cannot happen at all. We cannot eradicate it completely. But only thing is that balancing the interest of all the stakeholders in the financial market, because financial market is the backbone of the country's economic progress. Economy is depending on, apart from the other market, is the financial market. So strong financial market requires fair, transparent regulations, and SEBI is trying to regulate the same by even seeing that insider information are not doing any kind of harm in the market. So that's all for the today's lecture. With this, I'm concluding my lecture. Thank you.